Everybody. Hi. Good afternoon, everyone. Uh, this is Attorney Odunlami, immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. We serve clients in all 50 states. Please join me in this live session. And as you join me, please let me know you're here with me. Say hello. Tell me where you're joining in from. So, I don't have a topic I prepared today, but I just wanted to talk about a couple of case types, and I wanted to talk about something that came upon my spirit today while I was doing a consultation, right? So that's what I want to talk about. Hi, Tessie left. How are you? Hi, Faku01. Hi, guys. I'm so excited to chat with you guys. So, I had a consultation with somebody who had come in wanting one service, but I found out that they didn't qualify. But by asking a lot of questions, I was able to find something even better. So today's topic is just to talk about the different ways of getting a green card, right? And the value of a really good consultation, right? I'm always so excited when somebody comes, does a consultation and they tell me that they never heard about a certain thing. I get this a lot for U visa types. U visa are victims of crimes. Hi, Tessie, I'm good. Who tell me that they never even knew a visa type like that existed until they heard something I had put on social media, a live or a reel. So that got me thinking, because this happens a lot, and I just wanted to go over, just because you don't qualify for this does not mean there's no pathway for you. You just need to really, I always recommend that people have a really proper consultation, because I get people calling me all the time, and they want to ask a question, or they DM me with a question, but honestly, even if I respond to that question, it does not mean you do not qualify for another pathway. And you do yourself know, it's a disservice to yourself if you don't get a proper consultation. So for instance, I'll give you an example. I'll give you a couple of examples. A colleague of mine, another lawyer, she's a family lawyer. This was a year or maybe a couple of years ago. She contacted me because she knows, I do immigration. And she said, well, she wants to file for her niece. Actually, she sent me a text. I want to file for my niece. Can I file for my niece? So I sent her a text back. No, you cannot file for your niece because your niece is not your immediate relative. And then she said, oh, bummer. So I thought to myself, why don't I, schedule her for consultation, and let's have a proper consultation to see what else is going on with her family. Maybe her niece may qualify for something else. So we had the consultation, and I found out that her niece was on F1 in college here. I found out that her niece never knew her father. I found out her niece, the mother died not too long ago, and that after her mother died, she was brought to the United States to go to school, and because there was really nobody in that country to take care of her, and because there was so much trauma surrounding her mother's death, because her mother had died of debilitating cancer. So I said to her, well, how old is your niece? And I think she was 20, maybe. I think she was 20 or maybe 19. I said, you know what? We can file something called special immigrant juvenile status. And she said, what is that? I never heard of that. I said, well, it's a special pathway for young people to get a green card, but you have to prove 5 things. So I went over it with her. Number 1, the child has to be unmarried and has to be present in the United States. She was. We have to show that she has been abused, abandoned, or neglected by a parent. At least one parent, could be both, could be just one. Well, she had, because in New Jersey, death is an abandonment, which her mother had died, so it was equivalent to an abandonment. Her father had never been in her life, so that's an abandonment. That's neglect as well, because he'd failed to do his duty as a parent. And so we also had to prove that she was better off in the United States, which she was, because there was no family member left to take care of her after her mother died. And we also had to show that she was a person of good moral character, which she was. And we had to get a predicate order from the court, establishing all of this. So she said to me, but she's on F1, she's not undocumented. I said, it doesn't matter. Nowhere on that list did it say you have to be undocumented. It doesn't say that. So it doesn't matter. So we filed the petition. We got the predicate order. With the predicate order, we filed an SJIS petition with immigration. And a year, I think it was almost to the year, right? And I remember I came to my office because I got the green card, right? She didn't even have an interview, so I got the green card. And so I called the aunt. I said, I have a green card and I see that your niece's birthday is coming up. So you guys come to the office and we'll present her with her green card on her birthday. So that's what we did. So they came to the office and we had the green card all wrapped up. And I know she was thinking, what's this all about? Well, that was the good news. But what my point here is, if we had stopped at that first question, can I file for my niece? The answer would have been no. And if I didn't go further, then this wouldn't have happened. And this is what a consultation is all about. It's a fact finding. You don't qualify for this. Well, do you qualify for this? So in law school, I went to Pace Law School in New York. We were taught by the Socrates method. So we're not given information, right? You don't learn things and regurgitate it back. They give you fact patterns and you're supposed to spot check, look at this fact pattern. Do you see an issue here? Do you see, can you make a case out of this? And the funny thing is, you may have 10 law students and they may arrive at different conclusions with the same set of facts. And that is what law is about, right? So sometimes it requires you to think outside the box. So the law may say this is the way it goes, but you're like, what if we make this argument that it could go that way? Because the law doesn't say that and it doesn't say that. So therefore, we should argue it's fine. So it's important to have a proper consultation. And I say this because I hate for anyone to send me a DM or ask me a question here on a Facebook Live where I'm not your attorney, so I don't know the facts of your case. I'm just giving you information. And then you take that information and you're like, oh, that means there's no hope for me. And I hate for people to feel that there's no hope. There is hope always. Keep your ears peeled to the ground. A lot of, listen to what's going on. Do a consultation with one attorney, maybe two, maybe even three, because there are people who have come to me who said, an attorney said that we had no case. And I'm like, well, I kind of think this is we can work this case this way. And we've been successful. And I'm sure there are cases where I have said, I don't think this is a case that we can assist you with, and they've gone to somebody else. So it's really important to talk to a couple of attorneys and see, if anybody can assist you in your case. I had another case, which was a U visa case. So I talked about special immigrant juvenile status. That is a pathway for young people under the age of 21. In some states, it could be, when I say under the age of 21, that's in immigration. But the first part of the SJIS is getting a predicate order, and that is state specific. So in some states, you can only get a predicate order if you're under the age of 21. In other states, it's 19. In other states, it's 18. In New York and New Jersey, it's 21. I know in Georgia, it's 18 in Georgia, and in Texas, it's 18. But you have to be under 21 to file the predicate order with immigration, and immigration has to receive that predicate order, not filed by. Okay, they have to have it in their hand. So if you're almost going to be 21, you really need to, I mean, sometimes we've been able to work on cases like that by filing something called an order to show cause, which is requesting an emergent hearing because this is, an emergency. And so that's that. Now, I'm thinking of another case where a client came to me, the mother who is a U.S. citizen wanted to file for her child, but the child, her daughter, uh, she was actually over 21. The daughter came in. She was over 21, so she couldn't qualify for SJIS, but she came in through the border. And so I've said this before several times. Like, if you come in through the border, you're not inspected, you're not admitted. A family member cannot file for you. They can file for you, but you cannot adjust your status. You have to do it by way of consular processing, unless you meet specific exceptions, such as parole in place. If you have an immediate relative, a parent, a spouse, or a child who was in the military or is in the military or has been discharged from the military, and you came in through the border, right? You may be able to adjust your status if you file parole in place and you're approved, right? So those are the exceptions. But typically, if you come in through the border without being inspected, without being admitted, you cannot adjust your status. So when I told them that, we started looking at, well, what else? Because that's typically what I do when I'm doing my consultations. Well, if you don't qualify for this, let's look through other things that you may qualify for. Then I begin to ask more questions. So during the questioning, I realized that I think I said to her, well, have you ever been the victim of a crime? And she said, well, what do you mean? I'm like, well, have you ever had the police involvement in a case where you were the victim or you were a witness and you helped the police? Now, we're talking about the U visa. So she said that several years ago, her living boyfriend then had stabbed her while she was pregnant. And that was like, I think she said it was like maybe 14 years ago. And I was like, and what happened? And she said, well, I went to the police and then, they filed charges and he went to jail. I was so excited because we could file a U visa petition for her. Now, the boyfriend was not a U.S. citizen. She was not married to him, so she wouldn't have qualified for VAWA, Violence Against Women's Act, but she would qualify for a U visa. So we're really excited to put that, to contact the police to get the certificate of helpfulness, because for a U visa, you must get a certificate of helpfulness from the police saying that either you assisted them or you were willing to assist them. And the certificate of helpfulness does not mean that the person must have been prosecuted or the person should have gone to jail. No, it just means that the police says that you filed a police report, you were willing to, you were available to answer questions. Sometimes it could be just that. So that is the U visa, right? And now let's talk about the T visa. The T visa is trafficking. This is an area of law that a lot of people are not familiar with, right? And we've had quite a few clients that will file T visas for. T visa is labor trafficking or commercial sex trafficking. And we see this a lot in the area of labor trafficking, where somebody comes here, maybe they bring you here and they're under a false pretense. They say, you're going to come here, they're going to give you a job and you're going to do some work, and you come here and everything they told you about the job is different from what the truth was, right? Sometimes it could be construction. They tell you to come here, you're going to do this, and instead they're paying you very little money. They're putting you in dangerous conditions, and they're basically threatening you that if you don't comply, they will, report you and have you deported. It could also be in situations where, people are brought here to take care of other people's children, so you have this living nanny. She's not being paid adequately. They take her passport from her so that she can't leave. And, and she's afraid, she knows that she can't go anywhere, and she's forced to work all these hours at very little or no money. That's involuntary servitude. That's trafficking, right? And there's so many variations of trafficking because T visa is a whole, there's so much going on with it. or you have somebody who came through the border and was, accosted by the coyotes and forced to, carry things, and basically forced to, maybe they take them to a place like and force them to do work before they release them, right? So there are many various areas that can be, looked into to determine whether you meet the qualifications, right? And then we also have people who are married to U.S. citizens. And somebody says, when will you be talking about extreme hardship I-601 waiver? You know what? I've talked about that before, but I can talk about that next time, okay? I mean, actually, I love waivers. Love, love, love waivers. So happy to talk about it. So VAWA, Violence Against Women's Act. You're married to a U.S. citizen or green card holder and you're being abused, and it has to be a bona fide marriage. Remember, marriages must be real, must be a real marriage. Or you have a child who's a U.S. citizen and is 21, and they treated you badly, they're abusive towards you. We've had cases where you had the child sometimes under the influence of drugs or whatever, and they treat their parents badly, sometimes threatening them that they'll call USCIS on them if they don't get their way, they don't get the money they need to do certain things, or drugs or whatever. Or you can also file VAWA if you're a child of a U.S. citizen or green card holder, or you're the parent of a child that's been abused. And when I say child, I mean under the age of 21 that's been abused by your U.S. citizen or green card holder spouse. So that's VAWA, right? So guys, I don't have a lot of time, so I'm going to answer some questions quickly, but I will talk about maybe next week 601 waivers, 601A waivers. That we're going to talk about that. I'm really excited for that. Thank you for giving me that idea. So marriage is not the only way to get a green card. You can get a green card through employment as well. You can get a green card through humanitarian visas. There's so many of them. You can get a green card. You can even file for yourself under national interest waiver. You can do all of that. So I think if you decide that you want to come to the United States, you really should talk to a lawyer and see whether you qualify for any pathway. Or if you're here already in the United States, you should talk to one lawyer, two lawyers, a couple lawyers, see whether there's a pathway for you, right? So let me answer a couple of questions and then I gotta run, guys. So Vishal says, I filed my 751 back 2010. It got denied 3 times. Now I'm in removal process. My I-360 is pending. My wife don't want to give me divorce. So can you please tell me what I should do? So Vishal, you have a lot of immigration history that I would want to know about. I'd like to know why you got denied 3 times. And you have an I-360 that's pending, which is a VAWA. I hope that you have a good attorney working on that, because the I-751 denial makes me wonder why it was denied. So you want to make sure that there are no inadmissibilities. So I can't really give you any specific advice because I don't know what happened. I need to see the I-751. I need to review it. I need to know why it was denied. I need to know what's going on with your I-360 and all that. So I hope you have a good lawyer, because with an I-360, you can still get out of removal proceedings, right? But the denial of the I-751 is important, really important, because if you were denied for a sham marriage, that's a problem. And the I-360 that's pending, it takes a while, but just talk to a lawyer. That's what I have to tell you, because once you have immigration history, the history actually sometimes plays a huge part on your pathway going forward. Okay, Vishal? So Aman says, for family-based petition, does one have to provide tax returns above the poverty guideline above 24K for the last year, or does this poverty guideline rules need to be the last 3 previous years? So Aman, even though your question was a little confusing, I'm going to try to I'm going to answer it based on my understanding of it. So when you file a family-based petition, of course, you file the affidavit of support. And depending on how your household, the size of your household, that's what determines how much money you must make. Now, on the I-864 form, you must provide 3 years of tax returns, but you must put it down. But you can only you have the right, or you have the choice to attach just one. But the questions will ask you for the 3 previous years. You can attach just once. Typically, it's the last filed year that you use to show that you have the income. And sometimes we have clients that don't even have enough money the year before, but they're making enough money right now and making more than enough. We have the option to attach, a job, a letter from the employer, their pay stubs. That's an option. Sometimes we just say, you know what, just get a joint sponsor, because sometimes you just don't want, it's not worth the fight with USCIS sometimes. All right, I hope that answered your question. So I think that's pretty much it, guys. I don't see any question on Instagram. I think there's a question here, but somebody, Guarian X, said, I was a green card holder in US for 25 years. Now, after 13 years, I educated myself, becoming a lawyer in Dominican Republic. Congratulations, and now becoming an immigration lawyer just to be able to apply for a 601. So you didn't complete that, but I think it sounds to me that you were deported and you went back to your country and you're filing a 601 for a waiver. Well, depends on why you were deported, because sometimes when you're deported, you may not be able to come back. Sometimes when you're deported, you may be able to come back when you file the 601 for whatever misrepresentation or immigration law that you broke. And then you may need to file a 212. There's just so much information that I would need to be able to assist you, X Guarion X. All right, guys, I gotta run because I have to be out of here by 2:30. I have a consult, but I just wanted to chat with you guys. So next week I'm going to do 601. So if you want to hear about waivers, 601. I'm just going to talk about 601 waivers. So join me at my next live. Okay, take care, everyone. Bye bye.